Welcome back to Negligence, where we will continue our discussion on the individual elements. So far, we've started with the first element, and that is the element of duty of care. If you remember from video 2, the duty of care has two prongs. The first prong is to determine whether or not the defendant owes the plaintiff a duty of care. If the response to that evaluation is in the affirmative, yes, the defendant owes the plaintiff a duty of care. The next step with element 1, right? We're still under duty of care. The next step is then to proceed to prong 2, where we identify the duty of care that is owed. Video 2 focused on prong 1. Does the defendant owe the plaintiff a duty of care? If you remember video 2, we were introduced to 6 different tests that we can use to help answer that question. If you're not sure about those tests, I encourage you to go back and review video 2. But there's 6 tests that we use to determine whether or not the defendant owes the plaintiff a duty of care. I want to be clear. You have 6 tests to choose from. You don't use all 6. You just need one. And if from the one that you choose, it is determined that a duty of care is owed to the plaintiff by the defendant, you're going to do what? You're going to proceed to prong 2. Well, if I have 6 tests to choose from, in order to determine whether or not a duty is owed, how do I know which of the 6? Go back, review video 2. Low-hanging fruit, reasonable person test, generally one that will cover lots of circumstances. Not every circumstance, but lots of circumstances. But if I am your torts to professor, if there is a better test than reasonable person, but you choose reasonable person, you're going to get some points. You're not going to get the answer wrong. But if the foreseeability test fit better, or if the special relationship test fit better, and you chose to go the easy route, which is the reasonable test, reasonable person test, you'll get some points, but you won't get them all. All right. But again, that's video 2, where we establish whether or not a duty of care is owed to the plaintiff by the defendant. This video is going to focus on prong 2. I'm going to go back because I just want to, right? Duty of care. First step, prong 1. If that's established, we proceed to prong 2, which is identifying the standard of care that's owed. This video, we're in prong 2, where we're going to be introduced to several different standards of care. So you get the choice again, as you got to choose the test to determine whether or not a duty was owed. You also get to choose the standard of care. Okay. Let's go through it because there are quite a few standards of care, right? You see my note here at the third bullet. There's so many. I didn't even bother to try to count them. I know that there's more than 20, but don't allow your mind to run away with you just because your options are going to be so vast. Let's get through the rest of this video and hopefully this will start to become a little more clear. Prong 2 is to help us identify the standard of care that is owed, right? It will help us identify the standard of care that is owed. You know me, if you're one of my students, I like to start with definitions. So, how do we define the standard of care? Standard of care is defined as the level of caution or the degree of diligence that's required by the defendant under the circumstances. In other words, the standard of care tells us what conduct is required to avoid liability. What conduct is required to avoid liability. Before we go any further, take a second. We're going to look at the elements. Remember, my plan is that we will revisit these in each of the videos because I want you to become so familiar with them that it just becomes a matter of muscle memory, right? We have 5 elements. Why 5? Because I break actual cause and proximate cause into their own separate element. We start with the duty of care. In the common law analysis, why do we start with the duty of care? We start with the duty of care because if there is no duty, yeah, you're thinking about it, there is no negligence. If there is no duty, there is no negligence. Our first element is the duty of care. Our first element has 2 prongs or questions. Prong number 1 or question number 1, is there a duty? Prong number 2, identify what the duty is. All right, let's keep going. As with the test to determine whether or not a duty is owed to the plaintiff by the defendant, with the standard of care test, we also have a default. We also have a default. The default standard of care level, the default standard of care, right, is that of a reasonable person, right? So default standard of care is that of a reasonable person. Think about it. The default of the duty test is the test of a reasonable person. The default standard of care is the standard of care of a reasonable person. Now, I understand reasonable person is the same, but please understand that they mean different things in different contexts. Yeah. The test for duty, reasonable person, is testing for the duty of the defendant to the plaintiff. The default reasonable person standard is the standard of care, right? Now, you might have some readings that call this reasonable person a reasonable, prudent person. Same person, okay? Same person. So while there are many standards of care to choose from, the law often applies the default reasonable person standard of care, often applies the default reasonable person standard of care. But courts recognize that certain individuals, certain activities, and certain circumstances may demand a more specific or an adjusted standard of care. And if that is the case, then we have lots of other standards to choose from. I'm going to tell you just a little bit more about this default standard of care. The reasonable person default standard of care is the foundation of negligence law. This foundation stems from the Vaughn versus Menlove case of 1837. That's not a typo. Vaughn versus Menlove of 1837. This test is an objective test that asks how an ordinarily prudent person would act under the same or similar circumstance. It does not consider personal characteristics like intelligence or inexperience or mental capacity. It's supposed to be what? It is supposed to be objective. If you want more reference, look at Restatement Second of Torts 283, which affirms that unless the actor is a child, the standard of conduct to which he must conform to avoid being negligent is that of a reasonable man under the same or similar circumstances. So you've probably heard it. We've had this hypothetical person called the reasonable prudent person, the ordinarily prudent person, the reasonable prudent man, the reasonable man. They're all the same standard. Okay. But here's the concern. This standard is flexible enough to account for the situation um, oftentimes at play, but understand it does not adjust based upon subjective attributes because it's not supposed to be subjective. It's supposed to be objective, not subjective, objective. This isn't supposed to be what you would do in the same or similar circumstance. It's supposed to be what the reasonable person would do under the same and similar circumstance. In fact, if you want to know more about the characteristics or the attributes of the reasonable person, they have their own restatement of torts, which will explain to you all of the characteristics of this reasonable person, which helps you understand that this person is hypothetical. Okay. But the only way to make the test objective was to work with a hypothetical being. Here's an example I want you to consider. A driver traveling through a residential neighborhood at night. A reasonable person would anticipate that pedestrians may be crossing the street, and as a result, would adjust their behavior, would conduct themselves in a way that they would change the manner in how they drove to be more cautious, right? Neighborhood, night, people are probably out walking around. If the driver instead speeds through the area without headlights and hits a pedestrian, the standard for negligence is clear. Here's the reasonable person standard. Would a reasonable person have acted the same way in the same or similar circumstance? Clearly not. See how easy that test is? Right? And that one's not right. That standard, it's a very, very easy test. But again, not all cases fit so neatly into that framework. As a result, the law modifies the standard of care in three primary circumstances. The law modifies the reasonable person standard in three different circumstances. Circumstance one is when the defendant has a specialized skill. That means that we're going to have different standards of care. Circumstance two, when the defendant's personal circumstances warrant adjustment, then we're going to exercise a different standard of care. Or when public policy or statute imposes a specific duty, then we're going to have a different standard of care, right? That's why there's more than one. That's why the reasonable person standard of care is not the only standard of care available, right? The reasonable person standard of care alone is insufficient to account for the complexities of human conduct, human relationships, and societal expectations. While the reasonable person standard of care provides a baseline, right, it doesn't provide enough flexibility or variation that it covers all situations. So let's look at the charts that I've prepared. I've taken directly from the restatement second of torts, where you are going to go and look and verify content, verify number, but for purposes of illustration, we're going to get to those charts. So again, I've got a great standard, the reasonable person standard. It's objective, so it's going to cover a wide range of circumstances. It's relatively easy to execute, so we like it. There's not a lot of complexity about it, but we know that that standard alone is not enough, because if I have a situation where I have a defendant who has specialized skill or specialized training or specialized education, I'm going to want them held to a higher standard of care, wouldn't you? If the defendant's circumstances require an adjustment, not because of a subjective characteristic of the individual or a subjective trait of the individual, but maybe the circumstances warrant an adjusted standard. I need to have some additional standards. Maybe public policy or statute establishes a standard. Well, if public policy or statute is going to establish a standard, it's not going to be the reasonable person standard, because we already have that. And if that's what we're going to rely on, you wouldn't need public policy or a statute. Okay. So those are the reasons why we may need a standard of care that's different than the reasonable person standard. Well, let's take a look at some of these standards. General negligence, that's your reasonable, prudent person standard of care. How about a child who's doing a child's activity? Well, that would be an example where the defendant's circumstances may require an adjustment of the standard. Because if I have a child who causes injury to another playing jump rope or hopscotch or jacks or kickball, right? A child doing a child's activity, you wouldn't want that child to be compared to a reasonable, prudent person, because a reasonable, prudent person is an adult person, right? So that will be a circumstance when the standard of care needs to be adjusted. Well, I have a restatement second of torts 283A just for that. What if the child is doing an adult activity? What's an example of an adult activity? Driving. Whether they're driving go-karts or driving Sea-Doos or driving jet skis or driving snowmobiles, right? The driving is an adult activity. So if a child who is participating in an adult activity, then how is their behavior, conduct or action going to be judged? It's going to be judged based upon a reasonably prudent person. It's going to be based upon an adult, because they're doing an adult activity. There's so many standards of care. How are you supposed to know which one to choose? You're going to choose the one that represents the defendant in your case the most accurately, right? So again, you see on the left, you've got the situation. Does the situation involve a professional? Then I can look to the restatement second of torts 299A, which talks about the reasonable, prudent professional in the same or similar circumstance. What if I've got an abnormally dangerous activity? Well, we've covered the module of strict liability, so we understand how strict liability gets applied. What if we're talking about a common carrier or an innkeeper? That would be a hotel. Or premise liability for an invitee? Well, for an invitee, then the business owner is going to owe the highest duty of care to an invitee. What if it's a licensee? Or what if it's a trespasser? Or what if the trespasser is known versus what if the trespasser is unknown? What if there's a fiduciary duty? What is the standard of care now? What if it's a special relationship, like a doctor-patient or teacher-student or employer-employee, right? That's why there's so many different standards of care. Does that make sense? And so as you are completing your analysis, it's not like you're being asked to create standards of care. Really, you're not. You're just being asked to match the attributes and the characteristics of the defendant in your hypo with those that have already been established. Which one is the closest to what you have going on? Yeah. What about mental deficiencies? I think this is bad law, but this is the law. If your defendant has mental deficiencies, I'm sure my skepticism has already led you to what the standard of care is going to be. It's going to be that of a reasonably prudent person, not a reasonably prudent person with the same or similar mental deficiency. Yeah, no, right. Because as a history, we have a legacy of not trusting people. And because of the nature of mental illness and mental disease, and because of the difficulty to reach objective testing that confirms or affirms the presence of such a mental disease or a mental illness, we don't give any breaks to those with a mental disease or mental illness. We hold them to the standard of a reasonably prudent person or reasonably right, whatever the defendant might be. Physical disability, it's going to be a reasonably prudent person with the same or similar disability, right? But again, all of this is available to you. It's your responsibility to be familiar with them. You do not have to memorize all of them. Don't waste your energy or your resources to do that, right? Understand the intent. Understand the intent and allow yourself to reason your way through the analysis. The last standard of care that I'm going to mention in the video is a negligence per se standard of care. You see the box for the restatement rule and the box for the identification of the restatement is blank. That's because I'm going to leave that to you if you want to fill that in. And the reason that I let negligence per se be the last standard in the chart is intentional. Take note, please. Negligence per se has a dual ability. Negligence per se has a dual ability. Negligence per se can stand as a standard of care. Negligence per se can also stand as a separate evidentiary proof of breach of duty. Now, we haven't gotten to the breach element yet. That's element number 2. But I can use negligence per se as my standard of care when I'm in element 1 on prong 2, where I'm identifying the standard of care. I can name that to be negligence per se. And when I get to element 2, which is breach of duty, I can also claim that my proof to establish by a preponderance of the evidence is negligence per se. Okay, so if I name negligence per se as my standard of care, I can also name negligence per se as my proof of breach. obviously, if my facts allow. Or I can name negligence per se as my standard and choose another way to prove my breach or vice versa. So what I'm saying is there might be times where negligence per se may be the standard and the proof of the breach, or it may be one or the other. Okay. Real briefly, when is negligence per se a standard of care? Negligence per se can serve as a standard when that rule of law creates an expectation of protection. Creates an expectation of protection. For instance, a statute that requires schools to test for scoliosis. The school fails to test a student for scoliosis, technically, thereby violating the rule of law, right? Even if the statute itself doesn't explicitly address tort liability, a court, why court? Because a court is the one who's determining duty, right? A judge may determine that the violation of the statute created such an expectation of protection that failing to adhere to that layer of protection establishes the standard. Okay. And then again, the breach of duty, the evidence of the breach in that case would be the fact that the statute was violated. So negligence per se can serve as both the standard of care and proof of the breach of duty. So let's start from the beginning. If we are going to identify prong two, the standard of care, can you start with a reasonable person standard of care? Of course. Do we stop there? Of course not. We look to see if there is a better match in the prescribed standards to our defendant. If there's a better match, we're going to go with a different standard of care. It's about to get really exciting. This is the fun stuff. All right, here we go. Let's practice. It's an essay. Golden Glazed Donuts, a popular donut shop in Greenacre, encourages employees to make the shop feel warm and welcoming, like Grandma's kitchen. For years, Mia, a cashier at Golden Glaze, has shared a running joke with Tom, a regular customer. Each morning, when Tom walks in, he dramatically points at Mia and says, "Give me all your donuts or else." And Mia, always laughing, replies, "Too late. I already sold half of them and ate the rest." And there's laughs and there's joy and there's just fun. It's a playful exchange. One day, Mia calls in sick. Eli, a new employee, is called in. Eli has never worked the front of the store, right? And does not know Tom or Tom's running joke. Eli was in a frantic pace because he's running with fresh donuts from the back to the store front and icing them en route. So as he has the tray of hot donuts, he's coming out of the back. He's got the icing slathering on there, taking them straight to the front. Icing fell on the floors and flew all over. Tom walks in and delivers his usual morning playful threat. "Give me all the donuts or else." Unfamiliar with the running joke, Eli was startled to say the least. Thinking that Tom was serious, Eli runs from the back of the store with a tray of hot donuts in his hand, icing them on the fly. In Eli's haste and quick pace, Eli slips on the donut icing on the floor, and in turn runs into and knocks over a huge dispenser full of hot coffee that Eli had placed on the edge of the counter to cool with no top, just moments before. Excuse me for one moment. I'm going to fix this and then we'll jump back in. No top, just moments before. The scalding coffee spills on Tom, causing Tom to suffer severe burns on his arm. Eli had not yet completed the safety training that was required, even though he told his manager that he had. In addition, being called in unexpectedly, Eli forgot to bring and wear the safety shoes that were designed with traction to prevent falls. If Tom sues Eli for negligence, will he be successful in holding Eli liable? Discuss the duty of care and standard of care issues only. What does that mean? That means that you're just supposed to discuss those two issues, nothing else. That means you don't get to standing or anything. You may ask yourself, well, I understand that the call of the question is only asking me to discuss the duty of care and the standard of care issues. But what if I type quickly? But what if I process quickly and I have enough time to go ahead and address breach and causation and harm? Shouldn't I go ahead and do that? No. Respond to the call of the question. And the call here is asking you to simply do two things: discuss the duty of care and the standard of care. Okay, let's do it. If Tom sues Eli for negligence, will he be successful in holding Eli liable? Discuss the duty of care and the standard of care issues only. How many matters need to be addressed? Discuss the duty of care, that's one, and standard of care, that's two. But there's another question that's embedded there. If Tom sues Eli for negligence, will he be successful? That's a question. Slow down. Make sure you're answering all of the question. If Tom sues Eli for negligence, will he be successful? That requires a response. Discuss duty of care requires a response. Discuss standard of care requires a response. So make sure that you're answering all of the question. What's step one? We're going to draft an issue statement. If I am your professor, I have said to you before, I am not bothered if you want that first statement that's going to be read to be a conclusion. Great, then write a conclusion. If you want it to be a question, great, then write a question. If you want it to be a statement, great, write a statement. I know for a fact that I am not going to take points away from you because you frame it as a conclusion. I know for a fact that the Texas bar examiners will not take points away from you because you address it as a conclusion. I am not going to take points away from you if you frame your issue as a question. The Texas bar examiners are not going to delete points or fail to give you points if you frame it as a question. What is the purpose of that first statement? The purpose is to frame the question. That's it. Right? Why does that question need to be framed? So you can stay focused, not get off track, and start answering things that you were not asked. And it helps keeps the reader on track. That's why that first statement that we tend to call an issue statement is so important. If you are my student taking my exam, I've explained to you that the issue statement has three components. Of course, it needs to be a complete sentence. Of course, it should not be a run-on sentence. So grammatically, come on, right? Come on. Grammatically, it has to be a sufficiently written sentence, okay? And it has to be a sentence that makes sense, yeah? But there should be three components that's covered. And understand, I've said this to you before, sometimes you can't get it all done in one sentence. Sometimes you need two, okay? These are the three components that you need for an issue statement for me. You need the rule of law that you're going to use to solve the legal question. You need to identify the question, and then you need to have a dispositive fact. So here's an example of an issue statement for the donut hypothetical. Under the doctrine of negligence, did Eli, a food service employee, owe a duty of care to Tom, a regular customer, when Eli failed to wear required safety shoes and worked in a manner that created safety hazards, resulting in Tom suffering burns? If so, what is the standard of care that Eli owed to Tom under the circumstances? My rule is in yellow, negligence. The questions are in green. There's two. Question number one, did Eli owe a duty of care to Tom? You see, literally, if I just read the highlighted pieces, right? A food service employee, you can take that out. I put it in there because it was more descriptive. A regular customer, you could take that out. I included it because it was more descriptive, right? But what are the questions? I told you I highlighted the questions in green. You can see that there's two questions. Did Eli owe a duty of care to Tom? And what is the standard of care? What is the dispositive fact? That is, what is the fact that has occurred that if it hadn't occurred, I wouldn't have this legal question? Doesn't mean I don't have a different legal question, but I wouldn't have this legal question. What is the fact that turns this case for me? The fact that Eli failed to wear required safety gear, that's a big deal. Because had he worn the required safety gear, we might not be here, right? We might not be here. And if Eli had not worked in a manner that created safety hazards that led to Tom suffering burns, we might not be here. So I put two dispositive facts in that one sentence. Issue statement, 3 components: rule of law, the question that's actually being asked, and facts that, if they were not present, would either result in no question at all or a completely different question. That's my issue statement. So the way that I've set this up, I have one issue statement. Could I have separated the duty of care question from the standard of care question and treated those like 2 separate questions? Absolutely. Absolutely. Then I would have 2 IRACs, 2 rule statements, 2 sets of analysis, and 2 conclusions. Absolutely. Absolutely. I chose, exercising my freedom of choice, to write one issue statement. And actually, it's 2 sentences, but it's one statement. Got it? All right, let's go to the rule statement. What I want you to realize is what I did, the way that I'm organizing this is I have an issue, which is an I, and then I'm going to have 2 mini, MINI-RACs. I've got one issue statement. I'm going to do a rule statement, analysis, conclusion for standard of care. And then I'm going to do a rule statement, analysis, conclusion for, I'm sorry, got it mixed up. A rule statement, analysis, conclusion for the existence of a duty of care. And then I'm going to do a rule statement, analysis, conclusion for the standard of care. And then I'm going to do one overall conclusion. So I'm giving you an example of many MINI RACs, RACs. Okay, here we go. Here's my rule statement for duty of care. Under the Restatement Second of Torts, Section 282, negligence is defined as conduct which falls below the standard established by law for the protection of others against unreasonable risk of harm. One is liable under the doctrine of negligence if a plaintiff establishes by a preponderance of the evidence that the defendant, 1, had a duty of care, 2, breached their duty of care, 3, oh, wait, do you see what I just did? You see what I see? Yeah, let's fix that. 1 is liable under the doctrine of negligence if a plaintiff establishes by a preponderance of the evidence that, let's go ahead and put an article in there, the defendant, let's put a semicolon there, 1, here's my enumeration, 1, had a duty of care, 2, breached their duty of care, 3, was, there we go, the actual cause of plaintiff's injury, 4, was the proximate cause of plaintiff's injury, and 5, the plaintiff's harm that he suffered was compensable harm. Okay, so let's start from here. Looks like I think I had breach on the mind. I put breach as number 2, and then I put breach as number 2 before actual, and then I put breach in number 4 before actual. So I was thinking about breach. So we're not there yet. 1 is liable under the doctrine of negligence if a plaintiff establishes by a preponderance of the evidence that the defendant, 1, had a duty of care, 2, breached their duty of care, 3, was the actual cause of plaintiff's injury, 4, was the proximate cause of plaintiff's injury, and 5, the plaintiff's harm that he suffered was compensable. In response to the call of the question, I will only address the element of duty, which has 2 prongs. Here, see, I'm adding the rest of my rule. 2 prongs: 1, determination of a duty, and 2, establishment of the standard of care. Got it? Think about it. Why does my rule statement include a blanket rule about negligence? Well, one reason my rule statement includes a blanket rule about negligence is because when you're answering a question about negligence, you're going to include a blanket rule about negligence. That's one reason I have the 5 elements enumerated. What's another reason I have the 5 elements enumerated? Well, the first question that was asked is whether or not Tom is going to be successful in a suit in negligence against Eli. Well, if we're talking about negligence, in order for Tom to be successful in the suit or in the claim of negligence, he's going to have to satisfy all 5 of those elements. That's a question that's being asked, and there's a rule for that. There's my blanket rule. Why do I add the 2 additional enumerations? Well, because specifically, I'm being asked about the duty of care and the standard of care. And so I'm explaining that in order to address those specific mandates, I have to discuss the element of duty, and the element of duty has both of those prongs. Yeah. Why do I open my rule statement with this under the restatement second of tort section 282? Negligence is defined because I'm being asked a negligence question. So my rule statement actually has 3 parts. My rule statement for this particular hypothetical has restatement second of torts 282, which is a definition of negligence. It has the blanket rule for negligence, which lists all 5 of the elements, and it has specifically the rule for the element of duty, which has 2 subparts. Okay. Now, rule statement continued for the duty of care. The rule statement continued for the duty of care. Why do I add to my rule statement when I've already given the definition of negligence? I've already given the blanket rule for negligence, and I've already given the specific rule for duty. Well, because in this continuation of my rule statement, I am identifying for my reader the test that I'm going to use to answer the question about whether or not there's a duty. Remember, I have 6 tests. How does the reader know that I have 6 tests? I say there's several ways to determine the existence of a duty. I could have said there's 6 ways, right? It didn't need to be that specific, but I wanted to say something more than I'm going to use the foreseeability test because I wanted my reader to know that I knew that there's more than one way to do it, right? So I wrote that very first sentence. There's several ways to determine. Second sentence, for this case, I will use the foreseeability test. So I'm identifying my test. Do you need to identify your test? You need to identify your test. I'm going to use the reasonable person test. I'm going to use the special relationship test. I am going to use the public policy test. For this case, I'm going to use the foreseeability test, which states that a duty of care exists when a defendant's actions create a reasonable risk of harm to another within the zone of danger. You don't need to include a citation. Why did I include a citation? Because I want you to know where to go find this rule if this is something that you think you may need to use. I wrote see generally. Why did I say see generally? What does a citation of see generally mean? It means that I'm not quoting it, but for the most part, this is what it says. So see generally, restatement second of torts 284. I go on to explain when using the foreseeability test, because this is my rule statement and I'm explaining how this test is going to be used. When using the foreseeability test, there are two fundamental questions that must be asked. One, my enumeration, who are the foreseeable plaintiffs? And two, what is the zone or orbit of danger? Do I need this very last sentence? At its core, the existence of a duty hinges on whether or not the defendant's conduct created a foreseeable and unreasonable risk of harm to the plaintiff and whether the plaintiff was within the zone of danger. I don't necessarily need it, but it absolutely makes it very easy to transition to my next paragraph. And I take all of that into consideration when I'm writing. Well, I've got the rule. So I've got the rule for negligence, and now I have the rule for the test that I'm going to use for duty. Here, as to Tom, as a foreseeable plaintiff, Tom was a regular customer engaging in routine activity within the store, a setting where customers are expected to be present in an environment that was intentionally friendly and welcoming. See, I'm pulling facts. I pulled the fact that Tom was a regular customer. I pulled the fact that he was engaging in a routine activity because he came in every morning. I pulled out the fact that the environment was supposed to be warm and friendly and welcoming, like grandmother's kitchen. I didn't put like grandmother's kitchen, but I did put those other facts in there. I say a food service employee in a busy establishment should reasonably anticipate that customers will be moving throughout the store, interacting with employees, and encountering areas where food and beverage are handled. Are those facts that are specific to my hypothetical? No. Did I change the hypothetical? No. I drew out reasonable references. Why is he running through the store with hot donuts from the back to take them to the front if there's not customers in there to get the hot donuts? Why is he rushing unless it's busy, right? Because the nature of Eli's work required him to perform tasks in close proximity to customers. Is that what the back said? No. But if he's coming out of the back with a pan of donuts as he's trying to ice them and slips, and that slipping runs into wherever the coffee is, and that coffee falls over on Tom, we're not talking about a mega store. We're not talking about a mega store. We're talking about a place and a space where the workers and the customers, at least based upon the facts, seem to be in close proximity. Right. For those reasons, I say Tom was a foreseeable individual whom Eli's conduct could impact. He's a foreseeable plaintiff. In addition, Eli's conduct of running, that's from the facts, while icing donuts, that's from the facts, allowing icing to fall on the floor, that's from the facts, without cleaning it up. It didn't say that he didn't clean it up, but it said that he fell on it. Right? And placing an uncapped dispenser of scalding coffee on the edge of the counter, that's from the facts, were all acts that presented an obvious and foreseeable risk to anyone where? Inside the store. The combination of these hazardous actions made it likely that a customer would be affected, reinforcing Tom's status as a foreseeable plaintiff. Can this harm be anticipated? Furthermore, the type of harm suffered by Tom was not extraordinary. How did Tom get hurt? He got burned, By what? Hot coffee. Where? In the donut shop. Is that so unforeseeable? Not at all. How did he get burned? The coffee got knocked over. Where was the top? It wasn't on there, right? So all of these things putting together go down to my next to my last sentence, where I say a reasonable food service worker would anticipate that rushing while handling hot liquids and food products could result in injuries to nearby customers. Thus, Tom was not only foreseeable in terms of his presence in the store, but also as a likely victim. That answered my, is there a duty? Well, how do I determine it? I use the foreseeability test. What are the two prongs of the foreseeability test? Foreseeable plaintiff, zone of danger. My conclusion, see my C, my conclusion on the duty issue is because Eli's actions created a foreseeable risk of harm to a customer within the zone of danger, Eli owed Tom a duty of care. Get it? Here's my second RAC. So here's my rule for standard of care. Once a duty is established, the standard of care defines the level of caution expected of the defendant. The general rule is that a defendant must act as a reasonably prudent person. Why? That's the general rule under the same or similar circumstances. That's restatement second torts 283. However, if the defendant has a specialized knowledge or skills, remember, one of the reasons why you wouldn't use the standard of a reasonable person is if the defendant that you're working with has specialized skills or training. Remember, that's 299A if they're a professional. The law does not expect perfection, but it does require reasonable caution appropriate to the circumstance. Did I absolutely need that? No. But for me, it brought closer to that sentence, which allowed me to transition to the analysis. But you absolutely could have taken that last sentence out. Here's my analysis of the standard of care. A reasonable employee in Eli's position would have followed basic food safety procedures, ensured that slippery substances were not spread across the floor, and handled scalding liquids with caution. This includes properly securing hot beverages to avoid spills, wearing appropriate footwear to prevent accidents. Eli failed to meet these basic expectations. Despite being required to complete safety training, he had not done so, nor had he worn his safety shoes designed to prevent slipping. In assessing the applicable standard of care, courts would likely compare Eli's conduct to what? A reasonable person? Yeah. A reasonably prudent food service worker. That's almost like a professional, right? Such a worker would not negligently rush through the store while handling hot food or place an unsecured open container of coffee in a precarious position. By not following these fundamental safety precautions, Eli's actions fell below the expected standard. Technically, I just crossed the line into breach with that very last sentence, right? But what's the standard of care? Well, I identified it. I identified it as a reasonably prudent food service worker. Could it be a reasonable food service worker? Sure, right? Take prudent, leave prudent. What's the conclusion as to the standard of care? The appropriate standard of care was that of a reasonable food service employee, which required Eli to handle hot liquids and store conditions with care. What's my overall conclusion? How many questions did I have? 3. In applying the foreseeability test, why did I start there? Because it's a way to bring it all together. In applying the foreseeability test, Eli owed Tom a duty of care because his actions created a foreseeable risk of harm to a customer within the zone of danger. That's my is their duty. As an employee, his legal obligation was to exercise reasonable care in maintaining a safety environment for patrons, which included properly handling hot liquids and food safety hazards. The applicable standard of care required Eli to act as a reasonable food service employee under similar circumstances. That's my second issue, meaning he should have exercised proper caution in handling both food and workplace safety. Here's my third question, which was actually my first. As to whether or not Tom will be successful in the claim of negligence, the remainder of the conjunctive elements would have to be applied to make the ultimate determination, which cannot be made at this time, since the call only asked that the duty of care and the standard of care issues be addressed. Done. See my IRAC with my mini. I did a RAC for duty of care. I did a RAC for standard of care. I did an overall conclusion after starting with an overall issue statement. And that's the end. Oh my goodness. We are done with the first element, which is duty. Does the defendant owe the plaintiff a duty of care? And if so, what is the standard of care that is expected? That's video 3, where we focused on prong 2 of the 2-prong duty analysis. I look forward to seeing you in video 4, where we're going to discuss breach of duty. Thank you for joining, and we'll see you next time.